ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ. ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ.
Number one,
weeks preliminary.
2, PP Kumar,
Weeks preliminary. 2 weeks preliminary.
In second matter,
4,
second matter, I think is dismissed for non-prosecution. It's recalled,
IA for recording is pending.
something.
Second time there is recalling application. So what is the file recalling of delay application for recalling? And let item number 2, let application for condonation of delay in seeking recall of the order be filed within 2 weeks, failing which appropriate order shall be passed.
number 4, Samoda,
Done. Learned counsel, the applicant submits that the needful has been done. Office to
5, Chandrasekhar Singh,
weeks preliminary. 2 weeks preliminary. Preliminary.
1, Reddy, Tea Party,
2 weeks preliminary.
P. Somata,
Weeks preliminary.
9, Nagaraj Arti,
2 weeks, madam.
number 10, Shivappa,
Weeks.
11, Pujappa, J.
Weeks.
12, A.
It takes to comply with office objections during the course of the day. Why? Placed on 10th of
The 30, the Rohini came. For 40, the Pure held a government advocate.
let
Previous.
HCGP praise fund is granted a week's time to enable him to file objections. List on did Fridays what? 4th November. It's not exactly week's time, 3 days time. Now file it.
15, CM Shivaprasad.
2 weeks.
68.
2 weeks. Please. You must find out. Yes. Yes.
20, yeah,
2 weeks.
15,
Taking 1 week time. There are 2 weeks.
Not
Not
correct.
but let her be under an impression that
18,
file leave appeal is as withdrawn.
19, Satish Chandra.
2 weeks.
21,
Weeks.
Chairman. Number 22,
2 weeks.
Mahadevi.
Weeks time.
Yes.
Yes, madam. Let him come. Tell her out other come. Pass over.
26. Yes.
Delay.
40.
Which is 26. Issue notice of idea 1 of 20. Record.
27.
Recalling. Is recalling Mr. Dismissal order dated. Recalled. Maybe whatever. WA is restored to 5. IA is allowed. List for orders on admission. Don't say anything. They will list it.
28. In RIDM.
Issue notice. Record.
29. Market.
Ready? Heard on IA 2 of 2022, taking into account. List for final hearing on. No, because you want your client is what happens to 2014 appeals where you people seek adjournment. We need to have a sense of proportion also, Mr. Merely because you want the judgment to be delivered at your client's residence before 1:30 today. We are not the courier service. But in this case, your client is seemingly a person who has booked a flat or something and he is the builder. So he wants that right away, the relief should be granted to him. But what happens, you should come after a while when in 2014 appeals and 2012 appeals, people seek adjournment. Everybody is well now. The moment we reach final hearing, they will be unwell and not available. And Dharwad bench, Kalburgi bench. This is the real act. So we are allowing it. We could have deferred it, but nobody, rarely people come forward with an application for urgent hearing. So we are allowing it. Understand? Let it operate. File an application for vacation of stay if you are so advised. That doesn't mean that merely because you want it should be done today and we should leave the court and go to your client's place to deliver the copy. Let's see, sir, this is your order. We have passed. Don't. What did Mr. Nataraj? Yes. Whatever date. Tell we will hear. December. What date? 3rd December. All. He has found out a very auspicious date for your client. Right?
5th December.
5th December. 5th December 2020. We hope that this is auspicious for you as well. We don't know. Interim order shall continue.
30,
IA1 of 21 is dismissed as seeks. To date, sir, there's no question of 2 days. Seeks leave of this court to withdraw. Accordingly, the appeal is dismissed as withdrawn.
31, 40%,
Yes. Modification.
Next application we had in the first place, in the first instance itself before proceeding any further in the
We can't direct the learned single judge. It's not a subordinate court, right? It's not a subordinate court. We cannot issue you after arguing the matter to some extent. You sought leave to withdraw and with the liberty to file appropriate application, file it. If it's not being heard, then the another step arises, or we can't issue any direction. Have you filed the application? What happened?
No, it is not yet.
So then you make the mention before the judge.
It is yet to be heard on second. It was set for second. I don't know whether it will be heard.
We also don't know what will happen on second. We also no idea. Absolutely. Tomorrow also what will happen, we don't know. This all misconceived, right? Why should you do like this, Mr. Heard on IA4 of 2022 after hearing the party in particular, we do not find any ground to modify the judgment dated so and so. Judgment dated 27/9/2022 passed in WA 737 part 2020. Accordingly, same is dismissed.
number 32, why Rajendra Shetty?
Issue notice record. Dismissed. Yes. Next.
Number 33, Kumar.
Mr. Nataraj. Sure. Sure. We will dismiss. A notice on IA1 of 22, 2 of 22 record. Same.
34,
Is on IA1 of 22 record.
35,
What impeding? Who has filed? What is it, madam? Mr. Ramesh, anything survives? What about in pleading? No objection heard on DA3 of 2022 for the reasons assigned in the application, duly supported by an affidavit, IA3 of 22 is allowed. Let amended cost title be filed within 1 week. Hearing. It is admitted for hearing? No. Let the appeal be listed for orders on admission on date. This month only. I mean next month. 22nd November 20.
With your lordships kindly in the connected matter, my lords, that is writ appeal 5732 of 2012, I have returned the file, my lords, to the appellant authority. I'll be filing a memo for retirement today itself.
Which case? Connected 36 point. All right, learned counsel for parties jointly submit that this appeal, this order is in 36.1. This appeal be de-linked with WS 363 bar 2013 and be listed separately for hearing. Learned counsel for the appellant based on is granted 2 weeks time to enable her to comply with office objections. What about 36?
In the city property and who is running the record. Now, the intention is that because there is interdependability, the strength of both the employees together come more than 20, therefore they are covered under the act. Now that order is passed at election.
But these two establishments are separate entities having different set of employees, different owners, and your authorities have found it to be so. What is wrong? She is a possible judicial authority.
How much is and restaurant are very different persons.
Thereafter, they have constructed the building and named the hotel as Hotel Sangeeta. Large portion is run by the firm and the portion meant for the restaurant is in the basement area of the portion meant for the leased out to Sundar. Now, at present, the same Ashok Pai is only running the restaurant. At the next page 2.
Leased out to Ashok Pai, who is running the restaurant in the name style of Pai Restaurant, whereas lodging is in the name of Sangeet Hotel.
But the property is leased by Ashok Pai only to Sangeeta Hotel. That is what is.
Whatever.
And
But
secondly,
they are two different entities, right?
secondly, before the tribunal, the appellate has got his word. It's specifically mentioned at page 59 annexure E, which is the order of appellate tribunal. Arguments were addressed from the side of the respondent and nobody appeared at the time of the argument. At least the matter could have been demanded and it could have been heard.
No, if despite notice you don't appear, that doesn't mean that.
The difference was because it was appellate tribunal.
So you are served with the notice, right? It's your choice. I mean, supposing in this petition you don't appear, and we pass an order. So can you say seek a remand before the Supreme Court saying that I was not heard? Choice is yours, not to be present, but notice was served. It's nothing but. Yes. Yes. This intra-court appeal under Section 4 of the Karnataka High Court Act 1961 has been filed against an order dated 19th of November 2012 passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of the appeal briefly stated are that the appellant is the Employees Provident Fund Organization. Full stop. The respondent number 1, Messrs. Sangeet Enterprises, which is a partnership firm, is covered under the provisions of Employees Provident Fund Act. Full stop. The appellant issued notice to respondent number 1 to remit the dues and to produce the required documents. Full stop. The respondent number 1 did not respond to the aforesaid notice. Thereupon, an inquiry under Section 7 capital A of the Act was initiated for determination of dues in respect of establishments, namely Sangeet Lodge and Pai Refreshments. Full stop. After the inquiry, the dues were determined. Dues under the Act were determined for a period from December 88 to August 1999. Paragraph. The respondents challenged the aforesaid order in an appeal before the Employees Provident Fund. Appellate Commissioner, EPA, Tribunal. Full stop. The tribunal by an order dated 25/5/2010, inter alia held that both the establishments, namely Sangeet Lodge and Pai Refreshments, are different, having different set of employees and different owners. Full stop. Paragraph. The order passed by the Employees Provident Fund Tribunal was challenged by the appellant in a writ petition, which has been dismissed by learned single judge. In the aforesaid factual background, this appeal arises. Paragraph. Learned counsel for the appellant submitted that the appellate tribunal ought to have appreciated that the restaurant and the lodging and the restaurant is being run by the same person. Paragraph. We have considered on the other hand, learned counsel for respondents in that very paragraph. On the other hand, learned counsel for respondents have supported the order. Paragraph. We have considered the submissions made on both sides and have approved the report. There is the order passed by the tribunal. To stop the tribunal for the valid and cogent reasons has held that restaurant and the lodging are two different entities run by two different owners and cannot be treated as one unit for the purposes of enforcement of the Act. Full stop. The aforesaid finding is based on based on material on record and cannot be said to be perverse. Full stop. The aforesaid finding of fact has also been upheld by the learned single judge. Paragraph. For the aforementioned reasons, we do not find any merit in this appeal. In the result, same face and is hereby dismissed.
I'm sorry, my lord.
Nothing. Submitted for hearing record. Admitted for hearing record. Learned counsel for the parties jointly submit that there is a possibility of amicable settlement of the dispute between the parties, and the parties undertake to appear before the Bangalore Mediation Center. Saturday? What Saturday? Okay. The parties are then directed to appear Bangalore Mediation Center at 3 p.m. on 5th of November 20. Yes, you should be able to do it. Yes.
K. Shantaraj.
admitted for hearing. Record.
Number 39, CH-2 already.
Admitted for hearing. Yes, Mr. Nataraj.
Number 2, admitted.
Admitted for hearing. Yes,
Number 14, non-witness.
admitted for hearing.
My lord.
This record.
Notice.
41,
Notice, my lord, will have to go, my lord, for.
I appear for the appellant, my lord.
Oh, which case? 41.
41, my lord.
So
So this is about that standing order matter where the learned single judge remanded the matter.
oh, this will be heard.
This is for hearing.
So we'll finish motion hearing and then take up only
As your
5.
lordship, as your lordship.
After a while, Mr. Karan. Yes,
number 42, is
admitted for hearing record. 43 to
number
49,
43,
43 to 45 admitted for hearing. 44 is admitted for hearing. What is Mr. 44? Is the degree? A dissolution of marriage can grant a marriage default. Yes. In the meanwhile, operation and effect of impugned judgment and decree insofar as it directs dissolution of marriage. Insofar as directs dissolution of marriage shall remain state. So this is 44, right? 45 admit notice record. 46 same order.
45 will issue only notice. 47 will not.
Acha. 45 don't admit, only issue notice. Yes, admit notice stay. Dissolution of marriage. 47 dissolution of marriage.
Rajesh Rao,
40 same order.
CH-2, number 49,
There is no stage.
for 48, my lordship.
It says Mr. 48 no stay.
7 also no stage.
47 also no stay. So 47 notice, admit notice record. 48 admit notice record. What marriage has been dissolved. Fine. Fine. Dissolution of marriage shall remain state. Yes. List for analogous hearing along with MFA number 205920 and MFA number
Vishnu Kumar, is what?
result admitted to operation defect of judgment is record. Yes.
First over matter, 55.
Yes, madam. What state? They are not complied. So what? What vacating now? It's vacated, right? What state? Granted. So what is the, where is the stay granted? Date of order? 25(8).
Which matter, madam? Which matter? Bill number 1.
Let's see, Mr. Diesel. 25(8)20. When was the order? (25)8).
No such order. Please,
Second. Huh?
second matter.
Second man.
In the second matter, madam, there are appeal number 2. Not
He has not filed any application. What? Interim order shall continue, we have said. So, no. What should you tell us? That though the order ceased to operate, but inadvertently it has been continued. You are telling us it is granted. It is not granted. No, that is fine. What we are telling you, you should be clear about it. This is not an order granting stay. 25/8/2022 is not an order. Where is the order granting stay? Initial order. 14/1/20. None for the appellant, even when the matter is called in second round, she so and so learned counsel for respondent. This is 25.1, right? So and so for respondent. Learned counsel for respondent submits that this court by an interim order dated 14/1/2020.
one is in appeal number 1.
Yeah. 17 she said. She doesn't know one. She refers this, another this. She doesn't know what to do. Yes, and argue. We asked you when it was granted. Say. Able to tell even the date. On 14/1/2020.
Appeal number 1.
In one's case. Yes. This court had granted an interim order on 14/1/2020 in RERA appeal number 1 of 20. The aforesaid okay, what have you written? How sentence begin? So and none for appellant, so and so respondent. No, not submit. Delete record. Perusal of record indicates that a bench of this court had granted a conditional interim order on 14/1/2020 in RERA appeal number 1 of 2020. The aforesaid interim order was subsequently modified on 24/11/21. It transpires that the appellant had not complied the terms and conditions of the interim order, and therefore the interim order has ceased to operate. However, the aforesaid aspect of the matter was not brought to the notice of this court when this court, by an interim order dated 25/8/2022, passed in RERA appeal number 2 of 20, directed continuance of interim order. Full stop. After perusal of the record, it is clarified that there is no interim order in force in these appeals. Accordingly, whatever IA 1 of 21 is disposed of. Fitted to file.
Right in the registry, madam.
Number 41.
Petition, appellant, my lord.
What synopsis they have given?
Synopsis, my lord, we have not given separately.
No, other side. Other side has given.
I mean, ನಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ copy. ಅದೇಲಿ ನಾವು
21 appeal.
$1.
Yes. How much time will you take, Mr. Rao? We are
Have
just
to-
wondering that this is 21 appeal and we have much older appeals of 2014, 15.
No, in the
Why we should
sense,
hear it out of turn? And that's why we perhaps thought, how much time will you take?
we will take some time because I have to cite some decisions, my lord. That will take some time.
Some
Otherwise,
means what- how much time?
if your lordship, if your lordship is with me, my lord, I don't have, will not take much. It will take some time, my lord.
Okay. Yes. Go ahead. Yes.
Regarding the age of superannuation, that is the question involved. My lord, the standing orders of this
It's an order of
establishment.
remand, right? It's an order of remand, right?
Yes, yes. My lord, where the learned judge, my lord, considers the finds fault with the certifying officer. Of course, there is the one legal ground, my lord, at the outset, which I may submit. And he says these grounds were not considered by the certifying officer and appellate authority. So I
Please
remand.
tell us facts, what happened? I mean, please tell us.
Yes. My lord, on the standing orders of this concern were certified, my lord, earlier certified on
Why this?
29/4/91. And where the age of superannuation was fixed, my lord, at as 58 years. Not really. Was fixed at 58 years, my lord. Page 162 is the standing order. I have produced, my lord, the original earlier standing orders which were certified. And there were no amendments subsequent thereto. Now, my lord, as a matter of fact, the government of Karnataka, my lord, amended the model standing orders pertaining to the age of retirement, my lord, from 58 to 60 years on 21.
17.
Yes.
2017.
The age of, just 1 minute. My lord, it was modified
27/3/2017.
27/3/2017, my lord. The government issued a notification that is amending the model standing orders. Page
207, 204.
Will you apply 207? May I request your lordship to
204.
kindly have a look at 204, my lord. Two not four is the Kannada version and the English version is 205. May I request your lordship to have a 205. Whereas the draft of the standing orders so and so, my lord, they were all published and all that. And rules, title, these rules may be called the Karnataka Industrial Employment Standing Orders Amendment Rules 2017. They shall come into force from the date of the publication. This is what is important. Amendment. Under the heading Model Standing Orders prescribed under Rule 3.1 for workmen excluding clerks and ministerial staff, in the entries at serial number 15A for the words and figures 58 years, the words 60 years shall be substituted. From 58 to 60 years, my lord, was substituted in the model standing orders as per the notification dated 27/3/2017. We filed the application, my lord. 15. My lord, we had filed even earlier an application for modification of this standing order to revise this age of superannuation from 58 to 60 years. That is on 15/6/2015, my lord. We had made the application even before the amendment. Before I proceed, I would like your lordship to kindly have a look at section 10(2), because it gives me, my lord, a right to seek an amendment under 10(2). That is duration and modification of standing orders. Section 10, my lord. Standing orders finally certified or accepted under this act shall not, except on agreement between the employer and the workman or a trade union or other representative body of the worker, be liable for modification until the expiry of 6 months from the date on which the standing orders or the last modification thereof came into operation. Subject to the provisions of subsection 1, an employer or a workman or a trade union or other representative body of the workers may apply to a certifying officer to have the standing orders modified, and such application shall be accompanied so and so. That is, my lord, procedure. The modification proposed to be made, and where such modifications are proposed to be made by agreement between the employer and the workman for a trade union or other representative, a certified copy so and so. So, my lord, we can make an application within 6 months. And my lord, I made an application for modification of the standing order. Now, the certifying officer allowed my application, my lord. Is it not 1311, my lord? He allowed my application, and then, my lord, an appeal was filed by the management, that is under section 6.
This is the order. of
Yes, my lord.
certifying officer.
Yes, yes. The appeal was also dismissed, my lord, where he considered all the aspects, and the amendment which I had sought was confirmed. It is that order, my lord, which was interfered with by the learned single judge. Your lordship may kindly see the order. It's a very brief order, my lord. Your lordship will kindly see. New Orleans.
32 to 38.
Yes, yes. 32 the order your lordship will find. Page 34. That is my 34 says, paragraph 2. The grievance of the respondent who were employees of the Grindwell Norton Employees Association filed an application for amendment of the certified standing orders of the company before the Deputy Labor Commissioner and certifying officer under the Industrial Employment Standing Orders Act. The amendment sought is that the existing standing order, clause 21, provides for workmen who have attained the age of 58 years will be retired from service, and the proposed amendment is to be modified from 58 to 60 years. Petitioner filed an objection, my lord, that it is in Canada. Then, my lord, the aforesaid objections have not been appraised by the Deputy Labor Commissioner and Industrial Employment Standing Orders Act, and also failed to consider each of the aforesaid contentions. Therefore, there is no non-application of the mind, so and so. Even though the petitioners have not questioned the validity of Annexure D, dated 8/11/27, passed by the Deputy Labor Commissioner cum certifying officer under the Industrial Employment Standing Orders Act, one has to draw the inference that the said order merges with the order of the appellate authority under order dated 9/8/2018, Annexure G, passed by the Additional Labor Commissioner and the appellate authority under the Industrial Employment Standing Orders Act, which is under challenge in the present petition. On the short ground that is the non-application of the mind in considering the petitioner's contentions, dated is passed by the Additional Labor Commissioner and the appellate authority, set aside, including the order of Annexure D, passed by the Deputy Labor Commissioner cum certifying officer, and while remanding the matter, the Deputy Labor Commissioner and cum certifying officer under the Industrial Employment to pass fresh order after due consideration, so and so. There is practically, my lord, no consideration of the case at all. What in this respect, I would like your lordship to kindly see section 3.
Yes.
Yes, sir. I would like your lordship to kindly see 3 sections, my lord. I would like your lordship to kindly have a look at it. One is section 3, my lord. and section 4 and section 6. Yes.
To see where the order by deputy commissioner and this. There is the application point and all that. Yes.
My lord, if your lordship kindly say, why I am saying, my lord, is the appellate authority has got the same powers, my lord, as the certifying officer. My lord, the order that was, my lord, confirmed was by the appellate authority, my lord.
So perhaps we should see those orders first and then. Go
Yes, my
into
lord,
text.
I'm grateful. I'm grateful to your lordship. Your lordship may kindly have a look at the appellate authority's order, my lord.
Page.
Appellate
100.
100, Allah.
100.
100. Page 100, my lord.
Annexure G.
Annexure G. Yeah.
Translated copy. I like that.
110 is the translated copy, my lord, into English. Yes, my lord.
Original order.
This is the appellate order.
Oh, original order.
Original order, my lord, is
100 to 100.
huh?
Certificate officers.
The certifying officer's order is
Page 71.
yes,
Annexure
my lord.
226 to 231.
71.
71 antalla. Yes, no, right. Just one. Then, how? May I read, my lord, the order? Yes. Labor category secretary, limited, Devanahalli Road, so and so. Then it's all particular. Considering the requisition submitted, considering the requisition submitted by the labor for amendment of clause 21 of the association order of the respondent company as per section 5(1) of the employment so and so, with respect to the application submitted, the amendment of clause 21 of the confirmation association order, the respondent company as per the employment so and so. Administration informed due to non-employment dated 26/7/17, administrators with respect to the application of the appellant submitted the below the mentioned objections to the application of the applicants. Informed that due to the amendment of 58 years to 60 years in the retirement age in the association order cannot be increased to the, my lord, I think the stand,
The translation.
I must apologize, my lord, to your lordship. The translation is
Very standard.
with your lordship's the due apologies, my lord, to the court. This is mere physical strain work like loading, unloading and other technical work in our company. Hence, the physical, some of the employees of the company are already absent without obtaining permission. Therefore, if increased retirement age, it is difficult to work as the physical strength of the laborers decreasing. It is necessary to adopt more technologies for survival of the company in the present market condition, but the present employees are not in a position to learn technology and expressing objections. If the retirement age increased is indirectly increasing the unemployment. If the retirement age is increased from 58 to 60 years, has to face the financial burden. Therefore, pray not to consider the application filed by the laborers for increase of retirement age. 8 hours of work has to be done with the machineries in the company. Due to the decrease of physical energy of the laborers, it is difficult for them to work. To increase the retirement age needs to be considered the type of the company work. The same is narrated in the judgment passed in the ITI Limited versus Venugopalan. The type of the work in our company is very difficult. Hence, pray so and so. For the above reasons, respondents pray before the authority to dismiss the application. Laborers filed further objections to the objections filed by the administrators by denying the contents made in their objections. This office containing 5 questions is issued both the parties in respect of taking the decision in respect of the retirement age and directed to answer the said questions. What type of work given to the employees? What is the method of wages given to the employees? What are the retirement benefits giving to the employees and what are the other facilities? How is the atmosphere at employment place and what is the retirement age for the equivalent posts of the area? At the time of giving retirement to the employees, how is the general method of previously adopted in this company? Administrators filed written arguments on almost repeated the points narrated in the objections filed before the authority. Thereafter, on 38/9/2017 and 21/9/2017, given opportunity to both the parties to appear for inquiry for their respective arguments and to submit their written documents. Both parties present inquiry proceedings and submitted their details. Considering the appointment, objections, written statement, information, arguments, and the available details in all the records submitted in the case, calmly verified respect of passing the amendment order as under Schedule 1 of the Karnataka Employees Association orders. This is
It is employment standing orders.
Association. Employment standing orders, model standing orders prescribed under Rule 3A for the workmen, excluding clerks and others so and so. My Lord, that notification I have already mentioned to your Lordship. It is increased from 58 to 60 years. He refers to that notification. Then, my Lord, notification issued by the Karnataka government on 17/3/2017. The below mentioned amendment made in the association order, except clerks and writing the
Writing employees.
and
Writing employees.
writing, I think, clerks in respect of association orders for employees in the clause 15A mentioned instead of 58 years to 60 years. Through the above notification in the model standing orders, fixed retirement age of the employees to 60 years. In the present case, there is a dispute between the administration, administrators and laborers with respect to the retirement age increasing by fixing from 58 to 60 years. Applicants in the written statement filed on for amendment in proper and legal in the present circumstances stated that most of the employees are retiring at the age of 60 years in the country. To support their argument, given examples of central government, state government, cooperative societies, teachers, doctors, private factory employees, Honorable High Court of Karnataka has passed below mentioned guideline judgment with respect to the amendment of the retirement age. Messrs. Yakin Limited versus so and so. It has been held that the amendment of at the instance of the workman in the certified standing orders have been rightly allowed by the appropriate authorities by enhancing the retirement age from 55, keeping in view the factors pertaining to the improvement in the standard of living, health, care, and increasing span of life. As such, the High Court will not interfere in a writ petition as well as the appeal filed by the management. Per amendment for confirmation, amendment of the association order under section 4 of the industrial employment standing orders, the below points, and considering them, I have come to the legal and lawful decision. Considering all the clauses fixed in the proposed association orders, whether the clauses provided in the draft association order applicable to the company, when verified from the guidelines verified, the amendment submitted by the workman came to the opinion that retirement age can be increased to 60 years and confirm the same. Association orders confirmed that the administration is supporting the employment association orders of 46. When verified, the draft association order guidance workman praying for amendment on the basis of the notification passed by the Karnataka government on 17/3/2017 came to the conclusion as implemented. The above decision and amendments decided to implement on the condition mentioned below and approved. Administrators shall follow industrial employment standing orders, rules under the Act and the rules, and the Karnataka employees so and so. Said confirmed association order shall bring into force as per section 7 of the industrial employment so and so. The association orders after confirmation by making the amendment shall be displayed so and so. I think that is not necessary, Miller. And paragraph at the bottom, your lordship may kindly see. The entire submission of the applicants and the administrators, judgment passed by the Honorable High Court, and the notification published by the statement of objections verified in detail and the property, I have come to the clear conclusion to consider the prayer made by the applicants for amendment of the retirement age from 58 years to 68 is legal to consider the application on the basis passed the amendment confirmation order as above. Applicant workman's prayer so and so. This is all the order. Yes, yes. But your lordship may kindly see the appellant, the appellate order, my lord. It is also in Kannada, the translation, my lord, is at 110. My lord, why I am sorry, my lord, I must, my lord, may I even make one submission, my lord? That translation, my lord, of the certifying officer was Namdalwa. Yes. Now please see the, my lord, 110. Your lord can skip off now. at page 111 at the bottom, my lord, it starts. Further, it is stated that it would be unreasonable for the first respondent to order the appellant company to modify the standing order based on the model standing orders. The amendment brought into force by the government is limited to the model standing order and does not apply to a certified standing order. It is not appropriate to order this modification. When there is a certified standing orders in the organization, therefore, they requested that this order be rejected. The first respondent did not consider the decision of the division bench of the Honorable High Court in the case of Venugopalan versus ITC Limited. The first respondent has not considered the judgment. The verdict applies to the facts and circumstances of the present case, and the first respondent in the present case has taken a wrong decision and ordered. Therefore, it is prayed that the appellate authority be pleased to intervene in the matter and reject the order of the first respondent and provide justice to the appellant. The government's amendment in creating a tough situation of unemployment by increasing the age of retirement age, the statutory benefits like gratuity, leave, and other liabilities has to be extended, and also requires statutory benefits such as deductible vacations, this is deductibles, liabilities has to be provided for the extended period. This puts the financial burden on the appellant company. An order issued without considering these matters is not fair. Physical and medical performance is required to operate the machines for 8 hours. Those who cross the age of 58 years will not be able to do this work. Even though the appellant has stated that the company cannot use such workers to get those work. The first respondent, without considering these aspects, has allowed the prayer of the second respondent is working with such workers. It is very difficult to remove the product. They have appealed to the appellate authority to take this matter seriously. The first defendant erroneously taken a decision and ordered for the increase in their retirement age from 58 to 60 years. He has referred to the decision of the Honorable Supreme Court of India in Beruni Refinery, Shramik Parishad versus Indian Oil Corporation, and stated that the same applies to the present case. In this decision, it is stated that during the existence of a settlement, no new demands should be placed. It is stated that due to this new demands, it will increase the financial burden. But the trade union has not followed the terms of this agreement. The agreement between the appellant and the second respondent dated will remain in force until 31/3/2018 or until new agreement is reached. As per clause 33C of the agreement, the trade union cannot raise any new demands. But because of these new demands, it will put a heavy financial burden on the company. But the first respondent misinterpreted this and ordered for increase in the age of retirement age of the workers from 58 to 60 years. For these reasons, Yes, my lord. May I proceed with your lordship's permission? For all these reasons, the order issued by the first defendant is not valid. Amendment order should not be considered. The order was issued on 28/11/17, and we had no information on this until the second respondent issued a copy of the order dated 17/11/17. The appellate authority has requested the dismissal of the order dated by the workers on the basis of the order issued by the workers. They have prayed that by considering the copy provided by the workers, this appellate authority to dismiss the order to make suitable modification to this order and restore the age of retirement to 58 years. The appeal was received so and so. Then, my lord, the second respondent filed their detailed reply dated 7/3/2018 to the appeal. They are self-explanatory. They have stated that the application filed on 15/6/2015 before the certifying officer and other documents submitted during the hearing should be considered as part and parcel of the proceedings. They have stated that their request to increase in the age of retirement from 58 years to 60 years is as per the law. The reasons given by the appellant in there that the increase in the retirement age from 58 to 60 years should increase the financial burden and affect the efficiency of the workers is baseless. The workers have embraced the new technology. Therefore, the objections raised by the management are not justifiable. Recently, the state government has also increased the retirement age from 58 to 60 years by an order dated 27/3/2017. For these reasons, the appeal must also be rejected. Further, on the points raised by the appellants in this appeal, they have countered sharply and stated that by raising the retirement age from 58 to 60 years, it would cause no harm. It would cause no harm to the production of the company. The certified standing orders of the company does not have conformity with the model standing orders. The appellants have not convincingly stated that all aspects in the appeal filed before the appellate authority, stating that their application is well under the purview of the law. They have stated that the appellants did not provide reasonable grounds for challenging the order of the certifying officer. The statements made about that all the activities in the factory, the nature of the work, the other objections made by the appellants in the appeal were baseless and unsustainable and do not deserve to get any consideration. And they have given the examples of many judgments wherein the courts in the past have justified the increase in the age of retirement. The state government on 27/3/2017 amended the model standing orders to increase the retirement age in industrial establishments of the company from 58 to 60 years, which is a positive development, further confirming that the workers' eligibility are improving in the state of total. Also, the government has increased the retirement age of the industrial establishments from 58 to 60 years. And after studying the pros and cons, it should therefore be considered the nature of the work performed by the workers in the appellant's firm in general, and there are no barriers to or health issues to perform such work. The physical work of loading and unloading is performed by young workers, and for 58 years and odd to work in machines with the technology ingenuity. Their age would not be a hurdle. The management conducts medical checkups for workers every year, wherein fitness is considered as one of the factors. Therefore, the statement of the appellants cannot be accepted. The certifying officer has provided many opportunities to both parties and has followed the principles of natural justice. In addition, the respondent trade union has submitted before the certifying officer the substantial reasons for increase in the retirement age for workers from 58 to 60 years, based on the certifying officer has taken a proper decision. Appellants have stated about the absenteeism of the workers. The appellant has certified standing orders. The management can take disciplinary action against the workers who are absent, who commit misconduct as per the certified standing orders of the company. Keeping this in mind, it is not the right to deny the increase the retirement age from 58 to 60 years for the workers. The appellants are therefore required to prove this by appropriate evidence documents, increasing the retirement age for workers from 58 to 60 years will not cause any loss to the appellant. But if this is not taken into account, it can result in huge losses for workers who have worked in the firm for many years. They have stated that the order by certifying officer is based on the submissions and documents based on the parties, and it is justified, and hence the appeal so and so. They have submitted the copy of the judgments of the Honorable High Court of Karnataka in WP so and so. Appellant filed a written argument. In the written argument, it stated that the order of the Deputy Commissioner of Labor and certifying officer of the standing order is not proper, and already the objections were filed before the first respondent and same to be considered as so and so, that your lordship. In addition, increasing the retirement age from 58 to 60 years will be a financial burden for the organization. The first respondent, the Deputy Labour Commissioner Certifying Officer, Bangalore, did not take into account any submissions made by the appellants in this presence. Unilaterally decided, the appellants also cited several court orders which were not taken into account by the first respondent. His orders. In many organizations, the retirement age is 58, with most of the firms not increasing 60 years. The first defendant has also failed to address these points. Even otherwise, the order issued by the Deputy Labour Commissioner of Labour and the certifying officer for standing order region 2 Bangalore is bad in law so and so. Then, my lord, paragraph, the appeal filed by the appellants, the written arguments and the written objections of the second respondent trade union and their oral arguments and the rulings of the Honorable High Court were considered. In the appeal and the written arguments filed by the authority, the appellant, Grindwell Norton Limited, has argued that by increasing the age of retirement from 58 to 60 years, it would cause additional financial burden on the company, affect the production, and would cause severe loss to the company. After a certain age, any worker needs physical and medical performance to work in front of the machines for 8 hours in a factory. But 58 years old workers will not be able to perform such tasks. They have said that it would be inconvenient for the appellant's company to get the production through the 58-year-old workers. Not only this, the prayer of the appellant even is after it was stated that it's not proper on the part of the workers to raise new demands, even though as per the agreement, the workers are not supposed to raise the new demands in respect to the order certifying the authority. On the contrary, the second respondent filed detailed objections so and so, denying the allegations. Not that I will skip off, my lord, because the same thing. Now, his order is 118, second. All the factors raised by the appellants, your lordship got it. All the factors raised by the appellants are not justifiable. Appellants' contention that the amendments was not a proper course of action while the settlement was in force is unfounded. Therefore, it is decided that all the objections raised by the appellants before the authority have no bearing. For all these reasons cited above, it is proved that the appeal filed by the appellants are not justified. The order dated passed by the Deputy Labour Commissioner and certifying officer under the standing order region 2 Bangalore, enhancing the retirement age of the workers from 58 to 60 years is justified, and with proper reasons. It is therefore held there is no reason and grounds in the appeal filed by the appellants to dismiss the order of the Deputy Labour Commissioner and certifying officer under the standing orders. There is no reason for the authority to reject the order of the amendment or the certifying officer as the response has passed the rational order only after hearing both the parties. The appeal is considered is a case without worth rejecting. The order in this case is being passed within the time limit so and so.
I could have passed an order to consider it.
And the order in the case is being issued within the time limit prescribed by the Honorable High Court on 2/3/2018. Another. These are the two orders, my lord. Now, the learned judge, my lord, does not refer to this order at all. To the appellate order does not refer to it at all. And your lordship may kindly see. Please see, my lord, section 6. May I proceed, my lord? An employer, a workman, trade union, or other prescribed representatives of the workman aggrieved by the order of the certifying officer under subsection 2 of section 5 may, within 30 days from the date on which the copies are sent under subsection 3 of that section, appeal to the appellate authority, and the appellate authority, whose decision shall be final, shall by order in writing confirm the standing orders. This is important, my lord. Confirm the standing orders either in the form certified by the certifying officer or after amending the said standing orders, or by making such modifications thereof or addition thereto as it thinks necessary to render so and so. Now, my lord, the power of the court, my lord, is coextensive with that of the certifying officer. Now, my lord, in this case, the appellate authority, my lord, has considered the submissions. That is, now, your lordship will kindly see. Now, there are two submissions, my lord, which were pressed before the courts were. One was, there was a settlement when I made the application, my lord, for the certification of the standing orders. That what happened was, when I submitted my general demands, my lord, I had made that demand, but your lordship will kindly see, I withdrew those demands. Please see.
R11.
Page
280.
Please see, my lord, page 280. Yeah.
280.
As already informed, in the negotiations, that is, my lord, age of retirement. It was included, my lord, in the demands I submitted. But here on 13/6/2015, before the settlement, my lord, I submitted a letter as already informed in the negotiations meeting held on the 11th instant. Please treat our demand number 26 regarding age of retirement of the workman as withdrawn. We will be taking up the said issue before the Deputy Labour Commissioner, Region 2, seeking amendment to the clause 21 regarding the age of retirement of these certified standing orders of the company. It is only after I withdrew it, my lord, I filed the application. So that was not the subject matter of this settlement. Now, my lord, so that contention is, your lordship will kindly see how the management cannot be sustained. My lord, there is a direct ruling also I have produced before your lordship. I can withdraw the demand and I can agitate it separately.
Finding on this. Perhaps we may not record a finding on this issue, whether you can withdraw demand or do what. The issue is limited, Mr. Whether learned single judge is justified in directing the remand. According to you, there was all objections by the certifying officer have been considered and adverted to by the appellate authority. Therefore, there is no justification of order of remand. And secondly, you want to say that the absolutely no reasons have been assigned by the learned single judge for ordering the remand. That's the point. Nothing.
Yes, my lord.
1 hour has passed by. Yes.
My lord, so I will not trouble your lordship with the.
No. We wanted to tell you what we will consider.
Yes, my lord.
And you are a senior counsel. We are bound to hear you. Go ahead. But we are telling you, we will not give a finding on this issue. Whether you can withdraw the demand and you can make an amendment. All this is.
My lord, all that I would say, my lord, is that the matter has been considered by the appellate authority. Appellate authority, my lord, has got the same powers as of the certifying officer. Under these circumstances, and over and above that, much is more important is when the model standing orders have been, my lord, modified. Your lordship may kindly see. And age of retirement has been increased to 60 years. No industrial establishment can say the age of retirement should be retained at 58 years unless there are compelling reasons. Why it should not be 60 years? Why it should not be 60 years? Your lordship may kindly have a look at section 3 and 4, my lord. I will only read section 3 and 4. Please see, my lord.
Yes.
Within 6 months from the date on which this act becomes applicable to an industrial establishment, the employer shall submit to the certifying officer 5 copies of the draft standing orders proposed by him in adoption, so and so. Provision, this is subsection 2 is more important. Provision shall be made in the such a draft for every matter set out in the schedule which may be applicable to the establishment, and where model standing orders have been prescribed. Here, model standing orders have prescribed the age of retirement shall be as far as is practicable in conformity with such model. In conformity with the such model. Then, my lord, please see section 4, my lord. That is a, yes. Standing orders shall be certifiable. When will they be certifiable, my lord? This is important. Standing orders shall be certifiable under this act if provision is made for therein for every matter set out in the schedule which is applicable to the industrial establishment, and B, the standing orders are otherwise in conformity with the provisions of this act, and it shall be the function of the certifying officer or the appellate authority to adjudicate upon the fairness or reasonableness of the provisions of any of the standing orders. So you have to show that, my lord, that these are the model, my lord, why the model cannot be used. I mean, cannot be applied in the particular case. Now, please see, my lord, why one important point which your lordship may bear in mind is, as a fact, 91, my lord, the age of retirement was fixed in this establishment. And more than 30 years have passed. And everywhere, my lord, the age of retirement today has been accepted as 60 years. The court cannot, my lord, ignore it. Or, my lord, my lord, I would like to cite 2 or 3 decisions on this aspect. For this, no evidence is required. Please see, my lord, may I request your lordship to see the compilation which I have filed. Since your lordship has put me on guard, I will not.
No. Feel free to argue.
No, I should also know my limitations, my lord.
No limitation. We learn from you. Yes.
Now, please see, my lord. Please see that page 15, my lord.
Page 15.
This is a constitutional bench decision of 1965. Please remember, my lord, the British Paints versus Workman. Now, please see at page 16, my lord. Page 16 at paragraph 5. This is what I would like your lordship to kindly see.
Yes.
Considering, my lord, in 1965, my lord, they are saying this. Considering that there has been a general improvement in the standard of health in this country, and also considering that the longevity has increased, fixation of age of retirement at 60 years appears to be quite reasonable in the present circumstances. Age of retirement at 55 years was fixed in the last century in government service and had become the pattern of fixing the age of retirement everywhere. But time in our opinion, has now come, considering the improvement in the standard of health and increase in the longevity in this country during the few years, that the age of retirement should be fixed at a higher level, and we consider that, generally speaking, in the present circumstances, fixing the age of retirement at 60 years would be fair and proper, unless there are special circumstances justifying fixation of a lower age. Now, my lord, that is I rely upon that sentence. Then your lordship may also kindly consider, this has been so stated, my lord, in next case, Imperial Chemicals, Supreme Court, paragraphs 8 and 9 at page 19 and 24. I will not trouble your lordship. This has been so stated in the next case, in the Telong also. Then, my lord, Burma Shell. Then, my lord, now recently, my lord, two decisions of this court, the division bench decisions, which I would like your lordship to kindly see what they have said. Supreme Court, my lord, in 4 or 5 cases, my lord, I have given those decisions. I will not read to your lordship now. I will not trouble your lordship. This, see, page 55 is the decision in paras 22, 24, and 25. 55 parasu. Note paras ಬೇಕಾದ್ದು. ಎಷ್ಟನೇ paragraph?
22, 24, 25.
ಎಷ್ಟನೇ ಪೇಜ್ಗೆ? ಮಾಡಿದ್ದೆ ನಾನು. ಇದೆಲ್ಲ ಬೇಡ. Your lordship may kindly have a look at them. Paragraph 23 at page 106. While dealing the next question, it is necessary. Paragraph 23. It is necessary to note that by the Amendment Act of 36 of 56, the certifying officer under the Act is empowered to adjudicate upon the fairness and all that. Afterwards, my lord, at page 107, starting with, the certifying officer has taken into account the overall standard age of retirement in the industry, as well as the age of retirement all over the world, and has directed the appellant to modify the standing orders, fixing the age of retirement at 60 years. Subject, however, to the condition that the workmen are to be found medically fit by the medical officer, and upon such terms and conditions as the company may in this behalf. Learned counsel for the respondent 12 and 19 has placed on record on the internet download from the Wikipedia website, which discloses that the age of retirement all over the world is not less than 60 years. This court cannot turn a blind eye to the improved health of the workman, the automation of equipment in the industries, which has made the work more easier, with all underscore the need to revise the age of retirement at 60 years. We cannot also ignore the fact, even in the government and all its undertakings, the age of retirement is fixed at 60 years. The Supreme Court of India, way back in 1959, in Gaskin Williams, the age of retirement of the workman be fixed at 60 years. And this trend has continued for over the years. The contention of the learned senior counsel, who has all the powers of a civil court under Section 1, ought to have inspected the industrial establishment of the appellant to ascertain the feasibility of revising the age from 58 to 60 years, is of no consequence, as the respondent has directed incorporation of the standing orders subject to the workman being medically fit. Here also, my lord, they are subjected to medically fit every year they have been. Same thing, my lord, in this case also. Then, my lord, the last case which I would like your lordship to kindly see is another division bench ruling of this court, my lord, with the your lordship kindly, that is Justice Krishna Dikshit and Justice Krishna Bhatt. That is Grasim. That is, my lord, page 111. I think I should have brought lordship your notice to 111, my lord. Paragraph 6.
Para B, para C, para D,
120, yeah.
ಹೌದು.
120,
ಅಲ್ಲಿ
120.
ಆಗುತ್ತೆ. ಇದು lengthy judgment.
Your lordship may kindly turn to paragraph 120, my lord. 120,
From page 120.
120, my lord, page. Increased life expectancy. My lord, the learned judge has referred to, my lord, elaborately this aspect. Increased life expectancy and the global trend of enhancing the retirement age can remain in can we remain oblivious? Learned judge, my lord, puts a question. Then, my lord, he refers to a foreign quotation. Then, indisputably, at page 121, after that quotation, indisputably, there has been exponential advancement in the field of medical science. Improved health or facilities do avail across income groups. This has not only increased the expectancy of life of people, but their agility levels as well. UN General Assembly, so and so. My lord, learned judge has referred, my lord, elaborately about this. Then, my lord, he has referred to, and he has once again referred to, my lord, the earlier judgment which I read to your lordship of Federal Mughal, which he says is the correctly laid down the law, and I do not wish to, my lord, trouble your lordship any longer as far as this question is concerned. When, my lord, judicially, your lordship can take note of the fact that today the age of retirement, the Honorable Supreme Court has stated, my lord, that should be the age of retirement, my lord, unless there are exceptional circumstances. And in this case also, the workmen are subject to medical, that is medically be examined every year. That's all my, much obliged.
Yes, Mr.
ಇದರಲ್ಲಿ ಇದು ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತಾ?
Document produced before the single judge.
Yes.
During the period of operation, having financial liability on the management unless financial
So, may I request my learned friend may speak to the mic, my lord. I am just not able to hear what he says.
Yes.
one not for the compilation.
Yes.
Page 104 of the compilation participants case, paragraph 7.
102, 120. Paragraph 102.
Not in page 104.
Page 103.
Para 7. It is in page 16 of the comparison.
16.
16.
60.
Page 16.
All.
Paragraph 1.
Yes.
As to the factory workman, their age of retirement should be fixed at a lower level. As work in the factory is more arduous than the work in clerical and subordinate staff. In this connection, reliance is placed on the decision of this court in Jessup Company, where one age was fixed for clerical and subordinate staff, and a slightly lower age was fixed for the factory workmen. Here again, there is opinion that generally speaking, there is no reason for making a difference in the age of retirement and between clerical and subordinate staff on the one hand, factory workmen on the other, unless such difference can be justified on cogent and valid grounds. It is only where work in the factory is particularly arduous nature, there may be a reason for fixing a lower age of retirement for factory workmen as compared to clerical and subordinate staff. This appears to have been so in the case of Jessup Company, for that was a heavy engineering concern, where presumably work in the factory was much more arduous as compared to the work of clerical and subordinate staff. There might therefore have been some justification for fixing a lower age of retirement for factory workmen in the case of those factories where the work is particularly arduous nature. This is not our law that this work involves the lifting of heavy machinery, and that was one of the objections given to the trade. The objection translation is very bad, but page 73. Page 73 of the appeal paper. The objection which we had raised was informed that due to non-amendment of 58 years to 60 years in the retirement age in association in standing law, cannot there be an increase in retirement. More physical strain work like loading, unloading, and other technical work in our company. Hence, some of the employees of the company don't have been obtaining permission. Therefore, increased retirement age is difficult to work as physical strain for the labor decreases. It is necessary to adopt more technologies to prevent the company from market. Current employees are not in a position to learn technology and expertise. And if they retire, this way, in their creating employees. Then subclause 6, 8 hours of work has to be done with the machine in the company due to decrease the physical energy of labor. It is difficult for them to work. To increase the retirement age is to consider the type of company work. Same is directly between the two. So, examining the nature of this point is not answered as well. Once again, if I written one, pointing out these issues, what we have been considered. Page 90 is the written argument 55 to the appearance of the there we pointed out one that there is a security, and secondly, the manufacturing involves heavy and manual work at page 90 clause H. Clause K at page 90. We are currently contending that there is absolute non-consistency. Once again passes the order identical to the original order. There is absolutely no consideration. The red order is at page 110. Okay, one para is relevant. At page 118. Last paragraph, page 118. All factors raised with the appellant was not justifiable. Appellant's contention that amendment was not a proper course of action when the settlement report is unfounded. Therefore, it is decided that all of this raised by the appellant before this was paid. Work for the operator is particularly arduous and hazardous, where workmen lose efficiency earlier. The documents which are on record show that at least some sections of the factory workmen and workers machines which resemble some in use in heavy engineering industry. On the materials, we do not find it possible to create a definite on the point. We can also note that whereas in engineering concerns in respect of the age of the generally divergence of opinion as regards operations in Bombay and Delhi. Much will therefore depend upon actual assessment of the nature of the work of the operatives to find out whether it is really so arduous and hazardous as to lead the certifying of the court in appeal to the conclusion that the property of superannuation should not be raised beyond 58 years. It is rather unfortunate that the industrial court ignored the prayer of both parties to make a personal inspection of the factory of the appellant to come to this conclusion. Such personal inspection would have been more valuable than oral evidence by the parties before the certifying officer. In this case, certifying officer went by his own previous impression without caring to inspect the factory. The industrial court ignored the joint prayer in that behalf. We therefore feel that the matter should be reinvestigated and certifying officer should inspect the conditions in the factory to come to a conclusion whether the age of superannuation should be left at 58 years, whether it should be 60 years. The other thing now after having realized it, now after that which is now ready for conciliate now. Is a new level, which is also which they will have to raise it. In this Baroni, you have shown the one which is 1991. Paragraph 9. It had specific mention about age and requirement. Law 19 was the terms and conditions of service as of not changed under this settlement shall remain unchanged and operative for the period of settlement. The age of retirement prescribed by clause 20 of the service standing law was left out in the condition of service which was kept intact by clause 19 of the settlement. Provisions of the standing order act to which we have adverted at least clearly show that the purpose of certified standing order is to define with sufficient precision the condition of employment of workmen and to amend them with the same. The charter of demands contains several matters touching conditions of service, including the one concerning the upward revision of the age of retirement. After deliberation, certain conditions were altered, while in respect of others, no change was considered necessary. In the case of the latter, clause 19 was introduced, making it clear that condition of service which are not been changed shall remain unchanged. That is, they will continue as they are. That means that the demand in respect to revision of age of retirement is not acceded to. By clause 20 of the settlement earlier, the union agreed that during the period of operational settlement, they shall not raise any demand which is through additional financial burden on the management and bonus. Of course, the proviso to the clause exempted matters covered under section 9A of IDA from the application of that clause. Even section 9A is not applicable. Therefore, was therefore made in observing when the settlement has been arrived at the workman and the company, which is still in force, the parties are to remain bound by the terms of the settlement. It is only after the settlement is terminated that the parties can raise any dispute for fresh adjudication. The argument that upward revision of the age of superannuation will not entail in the financial work cannot be accepted. The Act 20.2 Workmen who remain in service for a longer period not to be paid a larger amount by way of salary, bonus, gratuity, and workmen who will duly join the place of retirement. High Court was therefore right in concluding that upward revision of the age of superannuation would throw additional financial burden on management in violation of clause 21 of the settlement. Therefore, during operation of the settlement, it was not open to the workmen to demand a change in clause 20 of the standing order, because any upward revision of the age of superannuation would come in conflict with this. Therefore, the order, the order, do not consider these as
Yes, yes, Mr. Rao.
I have got only one, my lord, I should have submitted in my compilation, only one paragraph, my lord, of the judgment in Sangram Singh, my lord. I forgot to.
Yes.
I should have cited at page
216.
216, my lord, in Sangram Singh. This is your lordship, only one paragraph. ಇದು ಸ್ವಲ್ಪ ಇದು ಕೇಸ್ ನಂಬರ್ ಇದು ಇಲ್ಲಿದೆ 211 ಮಿಲೋಡ್ at 216 211 page 216, only one paragraph I want to read. This is the decision of the Supreme Court. The power of the court, my lord, is that however, paragraph 14 is not to say that the jurisdiction will be exercised whenever there is an error of law. The high courts do not and should not, as courts of appeal under Article 226, their powers are purely discretionary, and though no limits can be placed upon the discretion, it must be exercised along with the recognized lines and not arbitrarily. And one of the limitations imposed by the courts and on themselves is that they will not exercise jurisdiction in this class of cases unless substantial injustice has been caused or is likely to cause. They will not allow themselves to be blamed into the courts of appeal or revision to set right mere errors of law which do not occasion injustice in a broad and general sense. For though no legislature can impose limitations on these constitutional powers, it is a sound exercise of discretion to bear in mind the policy of the legislature to have disputes about these special rights decided as special as may be. Therefore, the writ petition should not be lightly entertained in this class of cases. My only submission, my lord, is when age of retirement and it is accepted at 60 years, merely because supposing, my lord, the certifying officer who is not a judge has not written the order properly, my lord, is not a ground merely just to remand it, my lord, in a very casual manner. Therefore, I would request your lordship to see that the order of remand, my lord, having regard to the provisions of this decision, and also having regard to the fact, my lord, substantial justice has been done since the age of retirement today is 60 years, and also the statute also has said so. Hence, I request your lordship to set aside the order of the learned civil judge.
That's it.
I am much obliged, my lord.
Uh, 60. Which is 67. He is opposing the prayer. He is opposing your prayer. No. Uh, uh,
Earlier mentioned on Friday. That's all the same curiosity.
yes. So. Yeah. So whatever, when do you want evidence? Next week. Mr. Ashok Karanalli, learned senior counsel for the appellant, prays for adjournment. We enable him to prepare the case and argue the same list next week. 67. Further hearing. Mr. Yes, have you found out what? It is 51.1 is already disposed of. 50.1. What is the WA? Correcting. Already.
Because the
Ah.
Supreme Court has,
It has disposed of. No?
the Supreme Court has said the review is required.
If we review the order, then what happened? So what have you found? When? When? What? 3, 4? 10 lakhs. But which date 10 lakhs was paid by way? 3, 4. No. 10 lakhs by check.
Lakhs by check on what date?
And how much cash was paid? Cash. 16 lakhs.
$17.4. 49 lakh. Cash. Check. When was the check encashed? When was the check encashed? Four, the check was issued. When was it encashed? Huh? How can it be on 10/4? It is issued on 17/4. How can it be ensured? When was it realized? When was it realized? When was it realized? Sir? When was the check realized? You want the exact date? He had requested the government advocate to. He was sent it in the month of August. August. Record.
And tell them we had paid 10 lakhs cash and issue a check, 6 lakhs cash and we issue the check for 10 lakhs. 10 lakhs under the year no credit. You have no credit balance and then the initial deposit. It's very complicated. The need for the deposit and then only deposit, initial deposit. Related.
Where is that extract? You don't get it. But you have not produced the passbook to show that you had.
Yeah. Area. Yeah.
Give it to them, let him see.
They did not. They did not have cash melon on that day. On 3/4, when the check was issued melon, on the action day, where on the same day you have to deposit 25%, 6 lakhs and large is deposited for 10 lakhs melon on the same day, putting the date of that date on 3/4, melon issues the check. And on that day, he did not have cash melon in the bank. And the bank account shows melon and 10/4 it is then cash. It's all collusive by the melon authorities and the court respondent. Even the second payment also melon is highly belated. When we issued the check, he did not follow. The second check also melon. Second check also issued. The managed everything. Related. It did not happen.
Your bank statement showed that you had no cash.
Can go through this. Go through this.
There is no cash at all. Where is the bank's letter? Where is the bank's letter? Where is? Just go through this. You had no cash. You had no cash. You had no cash. Certificate is of no assistance for the reason. No, no. Maybe. 1 minute. 1 minute. You had deposited the amount, and that amount has been encashed. It is not the OD facility which has been given here. You had deposited. If you say that there was OD deposit, it was not necessary for you to deposit this amount. You had deposited the amount, and the amount was encashed on 25th, not on 21st. You had no cash.
Yes, that we have.
That
You are-
material only we are seeing.
Yes.
Para 21 is only with regard to the 25% deposit. Yes, please read the second part about. Yes. Yes, please read that. Where is the with regard to the second portion? Yes. 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 Right. 25%. 25%. Right. Yes. That was presented within 15 days.
That's not 1960, but consistently we are following. There will not be any restriction of this. What we are doing without recording the bank certificate, relying upon the bank certificate, the declaration is clear. Your lot of people all the reason. Yes. That can be a good. Who has no sources? And the government.
We will, Mr. Rajgopal, we will appoint you as Micus Curie every Friday. In all the review, we at least receive at least on Fridays, we deal with 10 review petitions. You have argued about the scope of the. Yes. Yes, yes, of course. Thank you. This is 2012 met. No inconvenience. 10 years, after 10 years, no inconvenience. So this time you will seek, then he will seek. So shall we list it after 10 years? 10 years. 2032, 33 sometime. No. Why are you not arguing the case? We will see what is it. Give it. They are not good for nothing. They don't want. No adjournment. Nothing. No pass. We have taken oath. We have to decide the case. We don't need your assistance. We'll say that you are not. He is seeking an adjournment. You are seeking a password. We are not prepared to adjourn it for a moment. Nothing. No password.
Password for what reason, Mr.?
So that it will not come, right? If on that it will not come, some other case will start. No, this is 10 years. 10 years, enough is enough. Nothing. Only a 2-page order. 2-paragraph order running into 3 paragraphs. If you can't read it, better do something else. Don't be in this profession. Development officer in Khati board without verifying necessary certificates on recommended payment of working capital with article inquiry held penalty pay for 1 year. That's it. Inquiry officer at that telling us, right? Disciplinary authority by taking. Yes. What is it? Why you are seeking a password? It will not be adjourned, Mr. You argue before Supreme Court that the court did not grant us adjournment, right? And our adjournment is our birthright, and High Court has denied it. Therefore, the order should be set aside. Argue before Supreme Court. We will say so. That we will record in the judgment that you are seeking an adjournment. It is not done. There is nothing. There is an imposition of reducing the basic pay for a period of 1 year after departmental inquiry. There is nothing in this case. What after 10 years, if you don't know this, better do something else. Don't be in the profession. You are wasting your time here. Right? We are sincerely advising you. Wasting your time in the profession. Don't do it. And don't come. We will decide it today. This will be decided today. No adjournment. It's your choice. If you want to read it, read it. If you don't want to, Mister, you will have to argue. We are just accommodating you for a password. That doesn't mean that it's adjourned. It will not be adjourned. You come, call your senior. We'll take it. Read the file, Mister. Read the file. No adjournment. Go through the file. That's what we are suggesting you.
They passed over the matter.
You have got lunch, Mr. Lakshmi. Tell him that he should sit here, go through the file, prepare the case, make notes, not run around and again appear for, we will not adjourn the case. Or you help us, you go through. He doesn't want to learn also, he doesn't want to read also. You go through the file, we will appoint you as a amicus curiae in his behalf. All right. If you don't even want to read it, you can't do anything. You have the file. Huh? You have the file or not? Huh? You have the file or you don't have? You have? Where is it? You see the court's file. Court's file. Give it. Give it to him.
Inform your senior that it is passed over.
No adjournment. Tell them that it's a bad court which is not granting adjournment. Tell bad judges. And God only knows who has appointed them as judges. Tell your senior that they are not granting adjournment. No. This is what we should do, right? 12 years matter. It's coming up after 10 years. 2012 petition. We should adjourn. Why? What makes you believe that it will be adjourned? Ridiculous, Mister. No. You challenge, make it a ground. We want to see that whether Supreme Court says that in 10 years old cases also this court should grant adjournment. You want to see, let it be set aside. You take a ground. We don't know what, it may be dismissed also. We don't know. If you don't want to come, don't come. But don't come for an adjournment. Got it? And see his file. You give him, he has see how good he is. He has given you his file. Sit down, study this file, make notes. Yes. Call your senior. They will take it up at 2:30 or whatever. Don't be under an impression that.
My lord, apparent for appellant, my lord. My lord, kindly. No, I kindly request you to pass over, my lord, because senior is held up with some other matter. So that requesting for 2:30.
You are not held up in any matter, right? That's why you are not held up by anybody or in any matter. right?
So
What is
requesting
it?
for, so 230.
All right. Acha, upheld the acquisition. Upheld the acquisition. How many years? How many years? 3 years. 3 years. A simple, Mr. Give the order. Last date also you did not appear. 2012 also you sought adjournment. So it's better don't appear. Entire
No, senior will appear at 2:30 minutes.
Go to 30.
Because senior is held up, my lord. Kindly requesting this
Take-
honorable, my lord.
Go ahead. Just give us the dates, Mr. What happened? Preliminary notification, when was it issued? Twenty-eight one. Huh. How much? How much? How much? 2 acres and 9 guntas and 1 acre. How much was notified to? Final notification, when was it issued? Ah. All right. They had filed objections also. The petitioners had filed objections. And when was the notification? Petition filed. Well, 6 years. 10. 9/9/2010. 10 or 9? Oh, which year? Which year? 2009 or 10, Mr.
Repetition of the year 2009, has to be 2009.
Yes, Mr.
My lord.
Okay. Paragraph. You have given 30.
You want a copy to the other side?
Application of the. Paragraph. The delay was.
Okay, Mr.
I think about the same.
Hmm. Yes.
Whether the absence of requirement that may not be used. Whether the activity you waste time. Whether the proceeding prescribed on 66 Act. Next to whether the activity procedure is one of the important part of the CH-2 and we are same day, what, one day, we will be. As well as, we can be, single.
Which paragraph?
What's the process?
All right.
Very small. Even when large extent land is acquired, parameters 8. Say that challenge the acquisition is more than 1,000 acres and made by this fraction of the land owners having and less than 10%. Here, it is any notification. Say that right. Yes, they are. The final application.
All right. Mr. Whatever you have to argue at 2:30. Right?
Yes, my lord. Much obliged.
We will close
Senior,
it.
senior will appear.
No, whatever you or
Yes.
senior, we are not concerned. Whosoever has to say, you say at 2:30, we will decide it otherwise.
Yes, my lord. Much obliged.
Yes. I will also then ask him to bring it back. No submission, no adjournment.
47 has been admitted already. The suit was dismissed. Suit is dismissed in the trial court.
You know, Mr. Case was called in 2 rounds. You don't remain present. And thereafter at 1:30, you will argue, right? We have passed an order. Challenge it before Supreme Court. Whatever you want. We don't know wherever you went. We called it in the second round, and second round we have passed.
Appeal is admitted and there is no question of granting stay. Suit is dismissed.
With your lordship's kind leave,
Number 53.
yes,
For is settled.
for the appellant's counsel, my lord. In
1
this
minute.
matter, please.
60.
64.
Settled. Yes, for respondent.
Reporting settlement.
Senate counsel for the parties jointly submit that the matter has been amicably settled between the parties. They, however, adjournment list on 9th November 2022 to report settlement. This is court hall moved, right? And he's seeking adjournment. What is this? Why did he seek then court hall moved? Therefore, you are seeking adjournment, right? Fine.
Yes, for the appellant's counsel, my lord. This matter, my lord. Yes, this matter, my lord. Counsel, my lord, the K. Raghupati, he is not well because, my lord, loss of memory. Now, what they're doing is, my lord, their office, my lord, they're making arrangements to distribute the matters to some other lawyers. That is how, my lord, this particular matter, my lord.
No, your colleague had appeared in the first round. We told him it's simple, right? Mister, we will tell you 2 or 3 facts, which is very simple. Right?
Please.
7/12/2005 preliminary notification under section 28(1), right? 4/1/2006 notification under section 28(2), then eventually 28(4), 31/8/2006 final notification was issued. This writ petition has been filed after 3 years, 9/9/2009. Adhesion was taken in the year 2006 itself. Allotment was made in favor of respondent number 2 in the year 2007. Thereafter, after 2 years, this petition has been filed. The single judge has non-suited you on the ground of delay as well as on merits. The sole contention is your contention that it can't be acquired for industrial area has not been accepted.
Yes. I will go through the papers. Yes. Before that, my lord. Before that.
Past.
I know that.
Over memory, we feel that we should decide the case.
Before that, my lord. My only request.
10 years.
This is only, my lord, the genuine request.
No, nothing. What genuine? That we have told you this is the case. If
Yes.
there is anything else, we will record your submission that you are saying that there is no delay in filing.
No. My submission is only this, my lord. 2 minutes, sir. Since, my lord, counsel is not well. In the sense, my lord, lost his memory. What they are doing is, my lord, they're making arrangements to hand over the.
Told you. How are you appearing?
That's the reason, my lord.
You will be representing the appellant.
Yeah, in fact, I have not yet filed the wakala. They will hand over the papers to me. I will file the wakala. I will argue the matter. That is the only reason. Otherwise,
next year or after.
No. Next week itself, my lord. That is the reason, my lord, I had to make this submission.
Monday.
Next Monday, Mister.
Please.
No adjournment on any ground.
Yes, my lord. I will not take any adjournment.
Don't go to Dharwad next Monday. So
Otherwise, your friend will tell us, because we are very allergic to adjourning cases which are pending before this court for past more than 10 years.
I know,
You
I
can
know that.
understand our predicament,
I
and
know.
please appreciate. I mean,
Please. I know
they
that.
do not take any pleasure in doing all this. But the fact is that if we adjourn a case 10-year-old, every other case we are required to adjourn.
Exactly, exactly, my lord.
That's the problem. All
Yes.
youngsters are watching us. They are sitting here for adjournment without briefs. And supposing if we adjourn your case, we have to adjourn every other case. That's our problem.
Yes, I will not take adjourn.
Of a judge,
Yes.
that he has to be consistent. We cannot
Yes.
adjourn your case, and in their case, we will tell them that. No.
Naturally, my lord, naturally.
So you are also suggesting that we should adjourn all the cases. And
No,
retire.
no. We should not.
No,
It should not be, my lord. It should not be.
not be. But you are asking for adjournment. What to
No,
do?
that's only on medical ground, my lord. Only on medical ground.
No, but Mr. We are making it very clear that we are adjourning it to Monday. No ground, no adjournment on any ground, whatever.
I
If
will
you
not.
don't
I will
appear,
not.
please
I will
don't
not. Yes, please. I will not take adjournment.
Don't put us in an embarrassing situation again on Monday.
Not at
We
all.
want, yes. We are telling you in no uncertain terms that we will not adjourn this case on Monday, come what may.
Please, please.
And we want it to be tested by Supreme Court. We want to proceed. You take a ground that this is it and the court refused to grant adjournment. We cannot compromise with our conscience, Mr. Doesn't it pains us really? Adjourning a case just like that. So it's easy for us also. We can enjoy our afternoon tea. It's painful. And so undertakes to undertakes to argue the matter on next date of hearing. Reluctantly, hearing is deferred. Just on 7th November 2022, it is made clear that no adjournment on any ground. And please do not send your junior.
No, I myself will.
There's no point. I mean, we unnecessarily put them in an inconvenient situation. We have read the case, we can decide it. And you challenge it on that ground that I wanted adjournment, court refused to grant adjournment. We want to test it, how Supreme Court reacts. Then we will adjourn all the cases at 10:30 then in that case.
Grateful.
Go ahead, Jen. Go ahead, Jen. Forget about it. If you don't want to argue, go out. We will not adjourn this. If you don't want to argue or you have no instruction, then don't. So that ground will be open. No? That court did not give us an opportunity of hearing and this thing. And in our absence, the case was decided. You should keep open the possibility of remand also. Right? Granted. Guilty and desertion. So when marriage took place, 5/6/2002, and when did you leave the matrimonial home according to the petition? Time has to. He must have said so in the petition, right? What date? What date? 2008 deserted.
Same. 40.
40. FT matrimonial home, 2/4/2003. When was the petition filed? When? Huh? 19/8/2010. Right. So 2 years completed. Fine. So what is the cruelty? You have left the matrimonial home, right? 2nd April 2008, you left the matrimonial home, is it not? You left. So what is your case? You didn't leave. You are staying with him. All right, consume. You were made to consume poison. Now, how many years? 14 years. Now, supposing if we allow your petition, will you go and stay with your husband? Not possible. Then what is permanent alimony? What do you want? What is he doing? Permanent alimony we are talking about.
Have you filed an application for permanent alimony? What is the amount you have claimed? What is the amount claimed by you, sir? 10,000 rupees per month.
That is 24. Hey, mister, you are married now, right? She is not married. You have to give her permanent alimony. How much will you get? How much he is not willing to tell us how much she wants. You tell us. What are you doing? Hey, what are you doing, Mr. Client, your client? IT employee? ITI? So,
Escorts. What is his
salary? What's your salary?
salary? What is your wife doing? Graduate, you said she is employed.
Who gives employment to BCom graduate, mister? That's what we are asking him. Who gives employment to BCom graduate? Probably Mr. Lakshmi Narayan may give. Government.
Any issues from the marriage? Any issues from the marriage?
How much? What's your salary of your client, mister? You come here only to seek adjournment, right? But what's the salary of your client? What is it? Hey, we don't know convicted. The question arises only survives only with regard to grant of permanent alimony, mister, nothing else. We are asking you how much are you expecting? You are not telling us. Fourth time we are asking you. Sit. We are talking about permanent alimony. Do you understand?
So permanent alimony, 50,000 per month. Okay. That's what we are asking. How much of amount would you settle for? Huh? Oh, of course, 40,000.
She is earning 40,000. This appeal was disposed of earlier. You had filed a review.
What's your salary, mister? How much he has claimed in the petition under section 24, mister? Tell us. No, how much he has claimed in a petition under section 24?
10,000 per month, yes.
10,000 per month. Mr. Natraj, please help us.
10,000 per month.
Petition under section. Following objection. What's affidavit? He set aside decision.
That was recalled. That was recalled.
So others on 24. That's what.
We confirm. We have the subsequent development. We confirm the judgment. Admittedly, it's not.
This 24 application. How much? 5,000. 7,000.
Claim 10,000.
7.
He has also got a lot of land. She has got. Trial court had rejected his 24 application. Your application was rejected by the trial court. So far as maintenance is concerned, it had rejected. Initial expenses correct, but so far as maintenance is concerned, it was rejected by trial court, and even this court has confirmed that.
No, that order operates like that order passed. So the your that order has been upheld.
Single judge has upheld it.
Single judges upheld that order. Rejecting. So for the proceeding pending before the family court, you are not entitled to any maintenance. And tell us why we should grant you maintenance under section 24 in respect of the appeal period. That's the only thing. You should. But why the judgment was recalled? They could be modified when deciding. 24 not decided.
Order, only order.
Why we should? It must have given some reasons. Hitting his application in section. Person has been believed that why it should be granted to you who have led the matrimonial.
Division bench of this court had disposed of this appeal, holding that the ground of cruelty is not proved, but desertion is proved. But it is recalled only on the technical ground that 24 application was not considered, but a finding is already recorded, which is there on record. It is not set aside, it is recalled. In review, it is recalled for the reason that 24 application was not considered.
No, now he is remarried, mister. What survives? You go and reside with him. Why should we examine? Read it, not through it. And the intention of the wife is not to do that. Some sort of force her to read it. Sometimes he will
Yes, she has attempted suicide after deserting. After the month of September 2008, you have deserted in the month of April or May. After 4 or 5 months, you have attempted in your house.
an admitted position. Let the matrimonial. This was sick.
It is also come on record that you have got a property of 2 floors. No, no, that is, now the property stands in your name. And you are getting rental income in respect of that property. Who is getting the income? The property is transferred by your brothers in your name. Your name. Then now you,
Property was gifted.
when
These are after the marriage.
you have deserted in the year 2008. If deed is dated 5/2/2010, you have deserted 2008. Therefore, it is not under his pressure. After your desertion, your brothers have gifted after 2 years after your desertion. What one is one of the reason you said because of his pressure that is gifted to you, which is totally incorrect. After desertion, 2 years of thereafterwards, it has been gifted to you. Whatever it is, the gift deed is dated 5/2/2010. And your father has come, has been examined. He has admitted that you are getting rent.
Other said so. Other said so.
Then who has to say now? Just now you said that parents are getting. He has said that you are getting.
In fact, parents are.
Your father has said you are getting. And admittedly, the properties have been transferred in your name. Gift deed is given. How can it be believed that your parents are given, your brothers have gifted that property to you? Your father even go to the extent of saying, my daughter has not executed GPA in my favor to collect the rent.
2002 to 2008. Those are early. Same there. Matrimonial. There is no income.
Alimony is after the disruption of the marriage, not while you are staying there.
So after that, you see that the after that, but the parties can live together. It's reasonable. There are also property. Bank loan property. Here also taken.
You have not proved that.
Yeah, give me the document. Do the document. Not include it.
Property. 3 floors in the property. In 2 floors there are 6 shops. And in the second floor there are 2 houses. So other place, 1 month, 10,000 for 1. 50,000. And according to her also, yes, sir, he is getting monthly 15,000.
And immediately after.
According to you, as per your affidavit filed in year 2012, his earning was 15,000 per month. What's that in your affidavit? 15,000. Even if it is now, we take it at double, it would be 30,000 per month. And no, people not, there is no question of granting you monthly maintenance. We will grant you some permanent alimony. Yes, how much you will pay permanent alimony? Huh? No question of informing.
He should give you 10,000 per month, right? Huh? But you have not filed any application claiming maintenance.
He's married. You're married? Huh? All right. Convicted because you done some offense. That does not mean you are not liable. Pay 3 lakhs permanent alimony. One time payment. Or monthly 10,000, which you want. Permanent alimony. Or 2 lakhs, mister. 3 lakhs you can pay. 3 lakhs. 3 lakhs, mister. You are earning, you have got property. Oh.
This and lakh.
Oh, no.
Next government alone. I mean, you have the.
Six shops and 2 houses in your property. That 6 shops and 2 houses. And your father has said 10,000 per month per shop. 6,000. We take it at 6,000. 6,000 in the year 2012. And 6 shops. Your father himself has said that I am not collecting rent. That cannot be believed, Mr. 2010 is the transfer. You have left the house in the year 2008. Huh? Eager means he also has to make a living. No? It is not only your interest, his interest also. You have got landed property, you have got your house of your own, you are getting rent from 6 shops and admittedly no issues. No issues. Then no, from this marriage, I'm telling you. He is married, therefore his responsibility is more. You have to understand that he is remarried, he has got wife, and from that 15,000 or 20,000, he has to maintain the other family also now. You have got source. You have got source because he has committed a mistake. We are token amount we are awarding. That's
Past third additional principal, Judge Family Court, Bangalore, in number 2679 of 2010, allowing the petition filed by the respondent husband under section 13(1) of the Hindu Marriage Act 1955, seeking dissolution of the marriage that was solemnized on 5/6/2002 at Balaji Kalyana Mandap, Mysore Road, Bangalore. For the first, parties are referred to as per their ranking before the family court. The marriage of the petitioner with the respondent was solemnized on 5/6/2002. And after a short period, the relationship between the parties was strained due to the frequent quarrelling that was taking place between the couple. Ultimately, the respondent wife had left the matrimonial house on 2/4/2008 without informing the petitioner and his parents, along with her belongings, and thereafter she did not return to the matrimonial house. The efforts made by the petitioner to bring her back had failed, and he had issued a legal notice to her, calling upon to join him. Full stop. Thereafter, he had filed the petition before the family under section 13(1), 1A and 1B. So that's right. With the prayer for dissolution of the marriage that was solemnized on 5/6/2002. The respondent, after entering appearance before the family court, had filed statement of objection denying the plaintiff petition. I contended that treatment meted out on her by the petitioner and his parents. He was compelled to leave the matrimonial house and take shelter in her parents' house. To substantiate the case of the petitioner, he had examined himself as W1 and not marked the documents as a P1 to P12. And the wife had examined herself as W1 and other was examined as P2. And she had 8 documents as a P1 to P8. Report. Right. The judgment and decree dated 2nd January 2013. Has allowed the petition filed under section 13 and so, and the marriage between the parties was dissolved. The agreed by this said judgment and decree, respondent wife has preferred this. For the counsel, for the petitioner wife, that full of assertion as well as cruelty was not good before the family court, and therefore the family court has allowed the submit that the respondent wife was constrained to leave the company of the petition
having got the harassment meted out on her by the petitioner and his parents. He also submits that it is the petitioner who was treating the respondent wife with cruelty and not vice versa. However, he fairly admits that the disposal of the petition by the family court, the respondent, the petitioner, has now remarried. Husband submits that it was earlier disposed of by this court. Order dated 7 December 2018, confirming the judgment and decree passed by the trial court from the ground of assertion. And the said order has been recalled only on the ground that application filed by the respondent wife seeks under section 24 of the Act of 1955 seeking maintenance was not considered. He submits that the ground deposit clearly go to respondent wife had voluntarily deserted the company of their weekend. And therefore, the judge of the family court was justified in allowing the petition. He also submits that the respondent is not entitled for any maintenance or not entitled for grant of any maintenance amount or permanent annual. She is guilty of deserting the petitioner voluntarily. He also submits that the respondent has landed property value and she is earning 40,000 rupees per month as rent, as rental income from the said property, and she has also got a house of her own to stay, whereas the petitioner husband is only earning the amount of 40,000 per month, and he has to look after his parents and also the second wife. You have carefully appreciated the arguments addressed on behalf of the parties and also parents. It is not in dispute that the husband has now remarried after the civil judgment and decree was passed by the family court, which is challenged in this appeal. Therefore, the decision of this appeal would be only academic and no purpose would be served. Judgment and decree. Right. Interfered. Yes. The only question that would arise for consideration. I will refer to the subsequent development during the pendency of this appeal. Only when that arises for consideration in this appeal would be whether the respondent wife is entitled for Went of any permanent alimony. Honorable Supreme in the case of so and so has held that marriage by virtue of court proceedings. Be a title for grant of permanent. The nature of this court in American number so and so has held that even if there is no application filed under section 25 of the Act, so while granting the decree of divorce, can exercise power under section 25 and for permanent alimony to the wife. The material of the court will go before that. The petitioner husband is working in a private company, and according to the respondent wife, he was earning a sum of 15,000 per month in year 2012, as could be seen from the affidavit in the examination, for examination in chief. When it is taken into consideration that he will be earning a sum of 30,000 per month as on the set income is required to take care of his parents and his second wife. The material of the court is to show that the respondent wife is owning a property in Bangalore. Consists of shops as well as residential premises. And she is earning rental income such building. There's also come under such property tax in her name, and her brothers have executed duty in her favor in respect of the said property. And RW2 has said that yes, she's collecting rental rent from the under the circumstances. There of the considered view, the petitioner husband is directed to pay permanent alimony of rupees 3 lakh. The respondent wife, that would serve the ends of justice. Following the following on, the miscellaneous hospital is disposed of the judgment and decree after the so and so court is confirmed. The petitioner husband directed to pay a sum of rupees lakh to the respondent wife within a period of 3 months. The deposit that 3 months. In a period of 3 months.
date of receipt of the.
3 months we have granted.
Rajaram Suryan bhai. Tika Devi.
You have to tell us what is the appellant's case and then what is the case. Ah. Ah. What now? Exemption. Fourth round of litigation. So they have become a court bird. Huh? They have become a court bird. So they want to be happy. Granted. Okay. It can't be granted retrospectively. Ah. 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 No, but it was amended. Where is the act? Which provision? Huh? 91A. Exemptions to be either for. Huh? Huh?
says that this amendment could be prospective or retrospective. The notification is issued to that effect. Notification for earlier period, retrospectively can be granted, then there should be notification. Prior to this amendment, is 91A coming into force.
Yes.
It was like either prospective or retrospective prior to the amendment. Either prospective or
Yes.
yes. But there should be a notification. Was there any notification during the earlier period? Is correct for the prior to 2010. Was there any notification? Where is that notification? Where is that notification? Where is that notification?
They did not apply their mind to this issue. But earlier they were granted both prospectively and retrospectively. They granted it retrospectively.
We continue in the list,
Yes.
but you come.
Let's say it's a time.
Don't like to. We will continue. Tomorrow is a holiday.
Next.
We continue in the list. What was the petition file? You have not given the date. Should have given the date right here. You are arguing 7 years. Where is the date? Date of filing of the petition. Fine. Yes. Patients to do what? What? Denotify the land. Denotify the land. (2005) you submitted representation on the ground that the beneficiary is not interested in the acquisition of your land. So it should be denotified. What is the other point? Position not. Yes. Page 126. 126. It is translation. What is it? AIADB Act. AIADB Act. So, all right. So what else? How does it? I mean, what does Mahazar show? Mahazar shows that possession was taken in accordance with 20. Fine. It says so at least. Translation, we don't know. Translation says so. Translation at 128, the heading is Mahazar. No, so we will go to what is the heading, but these are the 2 points that you said, and possession not taken. Fine. What finding? Ah. 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 Yes. Yes. One. Yes. Ah. Which judgment? It's really- Huh? Citation. Ah. Ah. All right. Ah. No, that is that this thing, if the land is not required, then total land is not required. Which paragraph? It's all. Yes. Yes. What happened? Not informed. What's the case? Whose petition? Husband's? What ground? What ground? What grounds? This intra-court appeal. Sit down, wait. This intra-court appeal has been filed. This intra-court appeal takes an exception to order dated 9th of November 2012, by which repetition by the respondent has been allowed, and petition has been allowed. The state government is directed to consider the case of the respondent for deletion of the land from acquisition through CIADPR. Development of 1966 paragraph. Giving rise to filing of this appeal. He stated that State government had issued a preliminary notification under section 28 within bracket 1 of acquisition of land situated in a Halli village in Nelmangla Taluk, measuring 18 acres and 33 guntas. The aforesaid notification, the land belonging to the respondent, measuring 3 acres, 30 guntas, 3 acres and 30 guntas of survey number to situate at one Halli, Nelmangla Taluk. Special land acquisition officer issued out of the aforesaid land. The owners of land measuring 15 acres and 3 guntas voluntarily handed over the possession of land to KIADP. However, the respondent who was the owner of the land measuring 3 acres and 30 guntas objected to the acquisition of the land. Thereupon a notice dated 21/5/2004 was issued to the respondent under section 28 within bracket 2 of the Act. And acquisition officer passed an order under section 28 within bracket 3 the Act on 25/6. The state government thereafter issued a final notification under section 28 within bracket 4 of the Act on 26/7/2004. It is the possession of the land was taken on 18/8/2004. After a period of 7 years, more than 7 years, a writ petition was filed by the respondent in which questioning of final notification dated 26/7/2004 issued under section 28 within bracket 4 of the Act was sought on the ground in the respect of the land belonging to the respondent. The learned single judge by an order dated 9th of November 2012. 9th of November 2012 as that held that the land measuring 3 acres and 30 guntas belonging to the respondent has not been utilized, and therefore the same has to be deleted in either in exercise of powers under section 4 or section 20 section 4 of the KIADP Act or under section 27 of PGC Act. PGC Karnataka General 21 of Karnataka General Clauses Act. Karnataka General Clauses Act. Karnataka General Clauses Act, right? It says KGC. Replaced, right? Karnataka General Clause. Karnataka General Clause. The writ petition was therefore allowed, and the state government was directed to consider the case of the respondent for deletion of the land belonging to the respondent. In the aforesaid factual background, appeal has been filed. Paragraph. Learned counsel for the appellant while inviting the attention of this court to the Mahazar submitted of the land in question. Possession of the land in question. Possession of the land in question was taken on 18/8/2004. This submitted that on 18/8/2004 and an award was passed by the land acquisition officer. It is further submitted that after the proceeding in the land acquisition case had concluded, after a period of 7 years, a writ petition was filed which suffered from delay and laches. However, and therefore ought not to have been entertained. However, the aforesaid aspect of the matter has not been appreciated by the learned single judge. On the other hand, in that very paragraph. On the other hand, learned counsel for respondent submitted that the respondent had submitted a representation in the year 2005 to denotify the land in question. It is further denotify the land in question on the ground that the beneficiary was not interested in acquisition of the land. It is further submitted that since the possession of the land in question was never taken, therefore the land had not vested in the court. It is therefore urged that that no interference is called for with the order passed by the learned single judge. Paragraph. We have considered the made interim notification in the instant case was issued, whereas final notification was issued on 26/7. Full stop. An award was passed by the Special Land Acquisition Officer on 18/8/2004. The writ petition was filed after an inordinate delay of after an inordinate delay of 7 years on 2011, for which no plausible petition was offered. Paragraph. It is right law. Is well settled. Paragraph. In the backdrop of aforesaid well-settled legal positions, it is axiomatic that no explanation has been offered by the respondent for approaching had been offered by the respondent for approaching this court after an inordinate delay of 7 years and in making a challenge to the final notification dated 26/7/2004. It is also pertinent to mention here that validity of the award past validity of the award dated 18/8/2004 passed by the Special Land Acquisition Officer was not questioned by the respondent. The writ petition suffered from inordinate delay and laches and therefore ought to have been dismissed on the ground of delay and laches alone. However, the aforesaid vital aspect of the matter was not appreciated by the learned single judge while passing the impugned order. Paragraph. For the aforementioned reasons, the order dated so and so Detail. Order dated 9th of 2012, passed by learned. Cannot be sustained in the act. In the result, appeal is allowed. What? Not happen. What's the case? Happened means not, we are not asking about whereabouts. Dismissed. So what ground it was sought? Not for the appellant, Mr. So and so, correspondent. What to be? Respondent. None had appeared on behalf of the applicant. 17/10/2022. 21/6/22. 21/9/2022. And 17/10/2022. Like below, it appears that the appellant is not interested in accordingly. Like below, accordingly, same is dismissed for want of funds. No adjournment, madam. No adjournment, right? You are smiling. That shows that you are ready to argue the case. Go ahead. What is it? No instruction. What is there? We will tell you 11th of January 2006. Parties got married 14th of January 2006. Left the matrimonial home. Petition filed on 24th January 2012 seeking dissolution of marriage on the ground of cruelty. See, final hearing also we are ready. So, as dismissed. No desertion. Then you have not proved desertion. You filed it on the ground of cruelty, madam. What happened? Not able to prove cruelty. Page 29. Adultery and what?
Could go to show that he was wrong.
Wife is married now. What? Not interested. Nobody is appearing.
Where is she?
Not responded. So what is the ground of cruelty, madam? But she has denied, right? And what evidence have you led? What evidence? No. Why are you seeking dissolution of marriage on the ground of cruelty? What ground, madam? Left means desertion. Leaving the home means desertion, right? 2000? Is it 2000? Citation. Ask. More than us. Well.
Which paragraph, madam? Don't read the head note, paragraph. Paragraph C.
There is no paragraph C.
Head note. Para 22 and 28.
Government from which cruelty is not. But what if the court says that you have not led any evidence to prove that he was roaming around with a right, your wife? The pattern says the evidence. No witness.
What is this police complaint? What you have given?
2013, passed by the Supreme Court. Dakshin Kannada Mangalore. In 13 1 of the English resolution of the marriage was solemnized on except Lions 7 and was dismissed. Responded those ordered has remained absent. That's leading to filing of this appeal. The appellant responded was solemnized on 11/1/2006. Even of forming the appellant or his parent. No, that only was in relationship. It was in the petition. One village, president of Vijnanapada, Bangalore Taluk. He was residing under the circumstances. But had lodged a police complaint. Jurisdiction before the Kaikama police station. On was at the intervention of the police, the respondent was brought back to the house of the appellant. However, in spite of afterwards, continued relationship with the said village. The appellant had thereafter brought in employment during the said period is telling that the respondent wife changed the appointment.
The appellant returned from better. Second was the police complaint before the Karnataka police station. That one went to the police parties to take their marital time. Accordingly, an agreement dated 14/10/2010 was executed between the appellant and the respondent. Agreeing to decide separately. The sum of rupees 35 some totally under the said agreement. Respondent had also taken all her belongings, including food and other valuables. And with respect of the same, the mother was also from which was signed by the respondent and her relatives. Afterwards, the respondent apparently did not cooperate with the appellant for filing a mutual consent divorce petition. And it is under the circumstances. The appellant had approached the court by filing a petition under 30 marriage at 1955. Seeking dissolution of the marriage. Respondent had entered experience in the proceedings and filed a statement of work denying the petition ever for the family court. That's PW1 and 3 other witnesses were examined as PW2 to PW4, whereas the respondent examined herself. The documents were marked as Exhibit P1 to P14 in support of the appellant's case. There were no documents were marked in support of the family court by OIT in judgment and decree was in judgment and decree as afterwards dismissed by the husband and being reviewed by the yes before this. Okay, respondent made absent. Submits that the parties are residing separately. Proceed year 2010. Submits that conduct of the respondent. It is evident from exhibit issue which was lodged by the current report jurisdiction police station. It is very clear that he was leading a unethical life even after marriage. Section 13(1)(a) of the Act for the purpose of dissolution of the marriage. Yes, this demands the judgment of the Honorable Supreme Court. Case of Matrimonial versus and so reported in What is the citation, madam, this one? Judgment citation. Not seen. Citation is seen, sir.
2012,
Reported in 2012-7 SCC 288. Yes, that will consider the arguments interest. The appellate. As alleged in this petition. Okay. Relationship that the respondent had. The wife friends. After her marriage was solemn. The yes. Let it be. Made by him in his petition. And nothing has been elicited from him in the course of cross-examination. He disbelieved the contention of this. In addition to the developments made by him, he has also produced exhibit with the police complaint which was lodged by him, alleging that the respondent was white. And he has also produced the Mazda, which was from subsequent to the said complaint. Why had the respondent had taken all the belongings from and had left him. He has also produced the agreement which was between the parties. Over 2010, produced as Exhibit P9. But reported in AR 2002-82. And that mental cruelty is a state of mind and feeling with one of the spouses due to mental cruelty can be by evidence. And it is necessarily a matter of inference to be from that result of the case. and circumstances are to be assessed emerging from evidence on record. Thereafter, a fair inference has to be drawn whether the petitioner in diverse fiction is subjected to mental purity due to the conduct of the other. In the current case, appellant has covered in detail that a police complaint has been lodged. After the police complaint, wife has collected all her valuables from the appellant and has left his house. Afterwards, the agreement was also executed between the parties. And who had agreed to live separately. Who has been served in the matter before this court last week, more than a year before this court. For a let's began the case. Further, parties are studying separately for the last more than 2 years. Honorable Supreme Court versus Dagos. 413 2007 for SBC. 511. Note that it are studied separately for a purpose would be serve them to continue with the marital tie. Sentiments of the parties are also requested to be respected. Whatever one Supreme Court has said, especially cruelty as an inseparable nexus with human conduct or human behavior. What is dependent upon the social strata or the piece of life, temperament, and emotions that have been conditioned by their social status. in 1A of the Act does not be defined. Could be mental. That could be differ from iterated the appellant during the course of his examination before the report and after considering the documents produced in support of the sentence raised that the crime report was not like using the petition filed by the appellant for dissolution of the marriage under section 31. Or in the following order, the MFA is allowed 10 degree so and so far. So it's set aside, and the marriage of the appellant with responding was solemnized on so and so date at so and so.
Yeah. Yes.
The agent, other side has taken time. 9 days.
Next matter, I am the respondent.
Yeah, sir.
Public.